one of the reasons why contracts, I think, matter is you're setting expectations on paper when everyone wants to work together. And so being, as clear and unambiguous as possible around what this is going to look like, I think is a helpful tool that is maybe not quite as legal, but it is going to avoid disputes.
You're listening to The Successful Bookkeeper with your host, Michael Palmer. Listen each week as inspiring guests share their secrets of success to help you increase your confidence, work smarter, and build a business you love. This episode of The Successful Bookkeeper is brought to you by PureBookkeeping.com, the proven system to grow your bookkeeping business.
Welcome back to the Successful Bookkeeper Podcast. I'm your host, Michael Palmer, and today's show is going to be a fun one. Our guest is the CEO and managing attorney at Equinox Business Law Group, Michelle Bomberger. Welcome to the show.
Thanks, Michael. Really appreciate you having me.
Hey, the pleasure is all ours, and we're happy to have you. And I know it's probably one of those topics that many people hope that they don't have to think about, but should be thinking about. And so I get the feeling this is going to be one of those episodes that gives people some ease of mind and some real good things to help them, anything when it comes to legal. And before we get into all of that good stuff, I'd love to know about you and help the listener understand who you are and your business journey leading up to what you're doing today.
Yeah, so I've had Equinox as the owner of Equinox for about 20 years now, or we're celebrating 20 years in next spring. But I never really planned to be a lawyer. And so I lead with entrepreneur a lot, as do many of your listeners, as folks who are running their own businesses, but maybe didn't ever intend to be in that space. My background is primarily business. I worked for Ernst & Young in the big four consulting and accounting firms. Went back to school to be a small business consultant and added the law degree as a tool to be differentiating, the ability to come into a business and provide something, a little bit different than the average consultant could bring. And it just turned out, leaving graduate school, that the business-focused lawyer was a really sort of compelling and appealing combination in the legal field. So I kind of took that path briefly, went back into business for a few years at AT&T Wireless, and then launched Equinox in 2005. So we've been building this model that is really around how do we help businesses be more proactive with legal. As most small businesses especially, know it's challenging to engage with legal. It's expensive. Sometimes you don't hear back. You're not sure you're getting something of value that you can actually use. And so those are the kinds of things that we're trying to tackle at Equinox.
That's very cool and very much needed. Now, we're going to be talking about legal advice and maybe not legal advice, information, and I'm sure there's some sort of disclaimer that would be great to have, and that's part of being prepared and proactive. You mentioned this before the show notes, which is you're being proactive. So let's maybe tackle that and make sure people are clear exactly what this is.
Yeah, thank you for bringing that up. So we obviously don't have a direct relationship with the listeners of the show. And so what we're sharing here is information. It's very general. I really encourage each person to talk with an attorney or an advisor that knows your specific situation before taking any action. So take what I'm providing as a guide, as a place to start. But you really need to have someone who knows the specifics in order to consider that legal advice.
Absolutely. And that is always the case. People pick up a template or some sort of document, Google it, get it, think, oh, this is good. Where they've just got a piece of information. They don't necessarily have any legal advice that's been given. So thanks for that. And we'll make sure that's in the show notes as well if people want to dig into that deeper and go for them. Now, our listener are running bookkeeping business owners primarily. They're located all around the world. You operate primarily in the United States, so I'm sure there's some differentiation there, which we can address as we go. But I think I get a sense from the feeling of the conversation we've had so far, this information is applicable wherever you are, for the most part, being proactive, to be thinking about this, to be taking some of these steps. So it's going to be very useful to our listener wherever they may reside and do business. What advice do you start to give to entrepreneurs that they can have some peace of mind knowing that they can withstand any legal action from clients and others? Where do people start? Where would get started with this?
Yeah, that's a really great question. So when we're talking about liability and risk, there's a framework that I like to share with businesses generally. And that is what I call legal infrastructure, which is just a term that I came up with to frame this. And I see three kind of tiers of protection, and I look at it sort of as a target, bullseye type target. And so the inner circle is your contracts. Your contracts are intended to set the ground rules for the relationship. That would be, what are the services offered? What are the payment terms? What are liability related risks? Dispute resolution, all of those things. And you put those into the contract in the hope and expectation that if something comes up, those contract terms govern. Those contract terms will take care of it and insulate that risk. But sometimes what happens either isn't covered by the contract or explodes outside of the contract. And then you're going to look to insurance. So insurance is what I would say is the second line of defense. So you have a slip and fall, or you have a virus that was uploaded, or you have a mistake that you made. Do you have insurance that then supports the contract terms? And so that's the second line of defense. So understanding what you need based on the kind of activities you're doing. And then the third, at least in the US, is your entity. Your business entity is typically a limited liability entity. It's a corporation or an LLC commonly. There are other forms as well. But what that does is that's if the whole thing explodes, contract explodes, you have some liability, insurance doesn't cover it, you have the ability to protect yourself personally from those liabilities of the business and just close the doors and walk away, assuming that you haven't signed a personal guarantee or otherwise put your personal assets on the line. So that's the framework that I like to talk with clients about, is thinking about every relationship and which of those tools applies. Sometimes it's all three, sometimes it's one. It just sort of depends on the nature of that relationship.
We'll get back to the interview right after this word from our sponsor. Tired of juggling manual admin and everyday practice tasks when you'd rather be nurturing more valuable client relationships? With the new Sage for Accountants, you can automate daily tasks and unlock not only more efficiency, but more time for valuable client collaboration with all the tools you need, including accounting, payroll, client management, and more, all in one place. Get real-time reports to make informed decisions, eliminate hours of paperwork, and say hello to stress-free bookkeeping and practice management with a centralized solution backed by expert human support. Learn more about the new Sage for Accountants or get started for free at thesuccessfulbookkeeper.com/sage. Thank you for hearing from our sponsor. Now let's get back to the interview. Very interesting. It's lovely to have it all sort of bundled down to three main categories that we need to think about. Has me certainly thinking about do we have our agreements in place? Are we insured and protected? And then how have we set up our entity to, fuel our business, but also protect our own personal assets and those sorts of things. Where do you handle all of those? Is it one firm that someone can go to or should expect that they could go to and handle all three of those? Or is it something that they need to go to multiple places to deal with these things? Or where should they start even? I mean, obviously insurance is done by an insurance agent or someone an expert in that. But the one and three sound like those, you have to be involved almost with all of those. But what's a pattern or a pathway that people might take for that?
Yeah, it's interesting that the industry has siloed itself so much that a lot of times businesses feel that they need or actually need an attorney that helps them with their corporate governance, and someone else who helps them with their contracts, and someone else who helps them with their employment and their IP. And I think it's part of the challenge of the industry overall, as, helping businesses to understand where to go. If you're able to find a business lawyer who first understands business, I think that's actually a really important differentiator. And there's not all that many out there, but that comes sometimes from experience in law for many, many years, but it also comes sometimes from experience in being in business and going to law school later. But that's valuable because you want someone who is able to talk to you as a peer, as someone who understands what's happening in the business. Because a lot of business decisions are not about risk. They're financial, they're emotional. There's a lot of reasons business owners are making decisions that are they throw risk out the window because it just, I'm going to sign it anyway. It happens all the time. So I think that's a really important factor. And if you can find someone who is more of a generalist, someone who can help you across the different parts of your business. And there are some that are more complicated than others. Employment, for example, is a really complex and constantly changing area of law. And so often that is separated. But if you can find someone who can understand all of the business items, then they get to know you. They get to know your business risk. They get to know your risk. They get to know how you operate. And it's not something that you have to then catch them up every 2 years when you call them, quote unquote, when you need them, but rather you build a relationship with them. And then that process of getting up to speed on the next thing that's needed is really quick. And so I think, it's something that the industry has made difficult, and therefore people don't have that relationship. So find someone that you're comfortable building a relationship with, and have a kind of regular engagement with them rather than a as needed engagement with them.
Mm-hmm. I think it's a great advice, really, when you're dealing with any vendor and partner, is do they understand the shoes you're walking in? And you've said, a lawyer that understands business and potentially in this scenario, small business, small, micro, medium-sized businesses. How do you know? How does one find that? You said it's kind of rare. How do you find that?
I think that's a great question. My experience is that, again, the industry has forced practitioners into silos. And so when you're looking for the experience of a lawyer, they would typically be talking about the fact that they do a variety of things. They're not simply real estate, right? Or they're not simply IP. Again, some of these are naturally separate. So I would look at their kind of bio and how they talk about themselves. And certainly if you can get a referral from another business owner, that is, an enormous, bump up on status for someone, is if someone refers them as a good partner. I would also look for someone who's somewhat flexible in how they engage with you. And that's also unusual, but becoming more and more common. So if it's, I don't know, it might take 2 hours, might take 12 hours. It is what it is. Like, that's not a great partner for a small business.
Mm-hmm.
Versus someone who says, hey, I can do this for a fixed price. Sometimes that's, for things that are highly predictable, that is available, and more firms are doing that. Or at least some sort of a, reasonable range and expectation, and certainly letting you know if it's going over that.
Yeah, absolutely. I think that's probably one of the big fears. And I know, I think it's Tony Robbins that says that the number one craving that humans have is certainty.
Oh.
And so going off and, that could take 1 or 200 hours, like how much is this that can create a lot of fear and with that uncertainty. And I would imagine there would be ways to, like, an example is, and I was just looking at your website real quick, you're in the Puget Sound area. This is Washington State. Right. We're here. I'm in Canada. You're in Puget Sound area in Washington State. Is it advisable to work with a partner that's in this scenario? Like, we have listeners all over the world. If they're in the United States, could they be contacting you, or is it better to look for someone local in your state, in your town? What's your thoughts there?
Yeah, so we are limited by licensing rules in each state in the US. So you have to be licensed in a particular state to represent a business in that state. There's a lot of reciprocity. So we actually have a presence in Washington, Oregon, Idaho, and Colorado in the US. Well, soon to be Colorado. We're not quite there yet. And so, yes, they would want to find someone who is licensed in the state that they operate in. It's gotten even more complicated as businesses have hired all over. They've got a lot of remote employees. They've got operations sitting in different, both domestic and international jurisdictions. But typically the rules are that, the company has to have a core nexus in that place where the attorney is licensed. And then many states allow for what's called a temporary practice, meaning I have clients who have employees in Oregon. Well, we're represented in Oregon, but in California, for example. So we can help them with that small situation, even though we're not licensed there, but we can't have a ongoing presence in there. So yes, there is a licensing issue. So they're going to want to find someone local.
Okay, very good. So, I mean, obviously going through their networks, asking who would fit that kind of model of understanding business, being able to serve small business owners. Are there networks? Like, how do people find you? What's the best way that your clients get to you and know, wow, you're amazing at this? What are some of the signs that you're doing might be flags for them to say, oh, this looks like someone like you?
Yeah, there's an organization, a professional networking organization called Provisors that is visible in many, many cities around the US. And that's full of all kinds of professionals. And I think building relationships with other professionals who are talking to clients of similar size and scope, so basically a similar niche, is probably one of the best ways to find other professionals. And so Provisors is a great example, but there are others. There's, Vistage, there's BNI, there's other groups to meet other professionals. But that, I think, is probably the place that I would look for my community of experts, my community of advisors. And those people are also then talking to similar clients. And so how do we build a rapport and be really clear about who we're looking for as clients so that they know who to send our way?
Okay, very, very good tips there. Now, let's maybe tackle some questions that focus on certain situations that would be useful to our listener in a bookkeeping scenario, business scenario. What legal actions can a bookkeeper take if a client fails to pay for services rendered or breaches a contract?
That never happens, I'm sure.
Never.
So the core of that is the contract itself. So get ahead of it. The contract needs to spell out the consequences of not paying. And a lot of times I see contracts that just are silent on that. There are payment terms, but there's no consequence. And I've always said, if you can be the squeaky wheel, the one that they're going to pay first because you have the terms that make it harder for them not to pay or more expensive if they don't pay, you want to be that squeaky wheel. And so that's, I think, something really important is to look at your contract and make sure that you have the teeth in that contract to take action. You need to take action. So that's the first. And then beyond that, of course, you've got things like collections and, failing collections. You could certainly go to litigation. Again, litigation is incredibly expensive, so it often doesn't get that far. Most states have small claims court, and these typically would fall into the small claims court thresholds. And so if you have a good contract and you follow your contract clearly, so don't let it slide for months and months and months and months and months where it becomes normal, but instead implement and be really proactive about, hey, payments overdue, I'm charging your interest charges, payments overdue. Don't let it slide, but be really, really aggressive at enforcing it after the first couple of months if you want to be softer. But that is the most important thing you can do, and then take the actions that you have the teeth in your contract to take.
Mm-hmm. What might be some teeth? So it's charging more. It's letting them know that it would go to collections after a certain period of time. Things like that. Is there anything that could put you into it's like how much more? Are there legal things to think about when it comes to what teeth you're putting in there?
Yeah. So be careful with things like administrative charges and, interest that is above the usury rate, things like that. So you want to be, again, squeaky, but not to a point where it would be considered unreasonable or unconscionable in the courts. So spelling out what the process is with some flexibility. Again, you don't want to lock yourself into something that doesn't make sense in a particular situation, but you want to allow all of your remedies to be available, but these specific things will happen. You're not your client's bank, contrary to some beliefs. And so, you're doing work for them and getting paid. I think, another option is if you're doing some sort of a fixed price, could you do it paid in advance? And then just making sure you're turning it off if, they fail to pay. So I think there are different ways of structuring payment terms to limit your exposure as well.
Absolutely, and that in this industry is often discussed. Getting paid up front, especially for rescue jobs, which we call. Someone hasn't done them for several years, and you go do all this work, and then they're surprised they don't pay you because they're in the situation. It's like those sort of situations follow each other.
That's a great point, though. I think setting really clear expectations as well. It's one of the reasons why contracts, I think, matter is you're setting expectations on paper when everyone wants to work together. And so being, as clear and unambiguous as possible around what this is going to look like, I think is a helpful tool that is maybe not quite as legal, but it is going to avoid disputes.
Mm-hmm. There's an interesting one that's come up a few times, which is you have typically in this scenario, you might have resources or documents or files that are the client's information and your, access to their accounting software, maybe even control of it. If someone doesn't pay, it's kind of a fine line. I mean, you do have some teeth there potentially with their information and holding it hostage. What would that be looked at in terms of being reasonable, or what the word you used, conscionable in the court's eyes?
I'm not a litigator, so I don't know exactly how a court would operate, and every state, of course, would have a different view of that. But I think oftentimes a contract has a term called work made for hire, right? So you typically have that in these agreements. If you create something for the client, it belongs to them. That's a pretty common term. So I think that is going to govern some of this work that the company is creating for the client. I think I have seen situations where documents won't be released until full payments in full. But I think if it belongs to the client, originally, I think it would be hard to do that, right? Mm-hmm. But if you're creating some sort of a deliverable, that deliverable wouldn't be released until payment in full. So if you're creating some spreadsheet structure or account management structure or tool, you could maybe withhold that. But I imagine that most of these are ongoing relationships, and so things are just being delivered on the day in and day out, month in and month out, and so that may or may not be applicable. It's hard to say.
It's interesting. I think the getting paid up front certainly solves a lot of that because there's ongoing work, right? So it's like, I'm going to do this work for this next quarter or month, and get paid before you do that work solves all the issues, because then you're working for money you've already received. And then maybe in the agreement, because you're working with software, and sometimes you do have administrative rights over that software, so you control it. So it might be just maybe that goes into the agreement saying, look, this software is administered by us, and will be transferred only under good terms or something like that. Might be fair. But it's those, go back to the contract, right? Okay, these are some ideas. What does our legal team think about that? Should we take it out? Should we keep it in, modify it? I think would be a great idea, but definitely some ideas there.
Yeah, I'd also just mention mentioned work made for hire. If you have created a tool set that you use for all of your clients, be cautious with that work made for hire language, because you're only transferring to them the right to use the deliverable that you're giving to them. You're not transferring to them the rights to the full tool set that you've created with your, experience and your time and your money. That's your IP. And so, especially in any kind of professional services or services business, we want to be really careful about what we're transferring. And it's not everything. It is the right to use certain tools. In many cases, again, software solves a lot of this. But I know a lot of professionals who put hard work into building tools, and you want to make sure that you retain the rights to those.
Absolutely. Fully aware of that. It's part of our business is developing intellectual property that helps firms use it. It's they have the right to use it and license the use of it, but it's not theirs, and it's not theirs to keep. It's a tough one when it comes to intellectual property, but bookkeepers have certain ways of presenting information, maybe ratios and analytics that they do. That's their philosophy, their process, and that's, again, needs to be documented in their agreement.
Yeah.
What about a situation where they discover, our client or our listener would discover illegal activities or financial discrepancies in a client's record? So it's like you're working on a file, and it's like, oh, fraud's happening, or something's not being done. How should they handle something like that?
That's a tricky one, because I think that it's to some degree dependent on who you're working with, right? If you're working with a really small business and your primary contact is the owner and CEO, and they're like the only person doing stuff, you're working with the person who is potentially leading that effort, right? Versus working more closely with an employee of a company and the owner's maybe unaware, right? So I think that there is a lot of facts and circumstances that play into that analysis. Again, first, I would make sure this is in the contract that says what happens, that you want to be able to terminate, first off. That's really important. And then, again, depending on the nature of what you're seeing, I would want you to build maybe a process or methodology that you would use as far as escalation. And maybe that's something that you could also share with the client as well, to say, hey, if I would discover this, here's my process. Here's what I'm going to do. Again, so you're setting expectations up front. And I'm sure that the client would always say, that's never going to happen here, right? And most of us don't believe that's going to happen here.
That's right.
But I think it's really valuable to be prepared for that. And I think it's a great risk management tool also, to be prepared for that and know what questions you would ask. Because I think that's probably where you would start is, where are the controls in this particular scenario? Who is involved in this process? Which then helps you to understand, who the players are and whether it is in fact what you believe it is, or whether it's something actually different than that. So I would be really cautious about, immediately going, with the accusatory route because of something you saw that was irregular, but instead be ready to ask the right questions so that you could escalate it if you felt like you needed to.
Very good.
Or remove yourself, which is the other really important thing, is the ability to remove yourself.
That's right. Some good tips there, and definitely key to have that exit strategy if need be. It's often we hear of owners wanting to do the way they think the tax laws should go, and that's a conflict of interest. It's like, it's got to be done a certain way. No, we should do it this way. That's one thing, but then also lots of story of fraud from both employees, family, and also bookkeepers and accountants, right? They're it's the keys to the kingdom, and certainly can get a little bit sticky when those things come up. Let's jump over to one here on that note, which is conflicts of interest that may arise when they're doing business with a firm.
Can you maybe share a little bit more about what you mean by conflicts of interest? It takes a lot of different kind of paths and storylines.
Yeah, it's a good question. Back to me, what is the conflict of interest? I guess it would be something along the lines of that scenario where a person is saying we should do the bookkeeping or filing, or like a particular expense perhaps, is this should be filed as X. It doesn't have a tax benefit. No, that should be a tax benefit. It's somewhat of a conflict of interest because they're asking and I don't know that it falls under that. They're asking them to do something that they think is a conflict of their interest, which is to maintain and do the records in a black and white fashion, right?
Yeah, I think remembering who the client is, I think is probably the most important thing that comes to mind in that point. If you're engaged with the business and your client is the business, and who is the business? The business is, ultimately the shareholders of the business, right? So if there are multiple shareholders and one is asking you to, or executives, I suppose, who are owners, asking you to do something that is adverse to the others, I think that's where I would raise caution. Certainly in our field, as lawyers, we have a specific client named, and when there's multiple owners in a business, our job is to represent the company on behalf of all of those owners. And so we can't do something for one person against another person. So I think that's the framework that maybe comes to mind in the example you provided.
Yeah, I think that would be definitely there where you have multiple owners for sure. That would come up. It's like and I've heard it from bookkeepers where it's like they have partners that are feuding, right? And then now they're getting involved and they have different opinions of what should happen or how it should happen or who said this, that said that. I guess protecting themselves against those things. But I guess another conflict of interest might be a good one is you're working with firms that could be competitive with other firms, like a restaurant industry. I have all restaurants. I have information about all those restaurants, or maybe restaurants isn't they're maybe a lot more collaborative or less IP that's happening there. But there could be other scenarios where competition's happening. It's in many, we talk often that's a good thing to do. You understand the industry, you're able to serve them better, but at the same time, it's like, wait a second, you're working with my competitor.
Yeah. Yeah. And again, we see a very similar dynamic in our world. I think the expectation, as you mentioned, is that there's value in the experience you have in working with lots of people in the same industry, right? I mean, there's real value because you've seen it before. You've seen how the accounts are set up. You've seen how certain transactions are structured. And your contract, again, typically has, confidentiality language, which is going to say, everything you share with us, we keep confidential. And that's something that is really important to maintain, because if you can't maintain that trust, it's going to be really hard to kind of keep the business going. And so while there's stuff in your head that you can apply to the next client, you wouldn't be able to say that out loud. Right. And you wouldn't be able to use it directly in that client relationship. However, the learning and experience is certainly there. So I don't think there's a problem with working with companies in a similar industry. The client may have a concern. And so how do you alleviate those concerns that the client might have about you working with their competitors? And they may choose not to work with you for that reason, but you want to be prepared to say, hey, here are the controls that we have in place. Here's how we handle confidentiality. Here's firewalls in some case between client accounts. So it's going to depend on the circumstance. I don't think it's necessarily a legal problem, but I do think you should be prepared to address it.
It's great. Some great thoughts there. And perhaps, some deeper thinking on what am I saying, what information do I have, being clear about what you're willing to share or can share that's not going to impact anyone adversely across those industries would be a good step to take. This has been great. I'd love to know if there were any other big ones that you can think of, advice that you think would help protect our listener from any issues down the track.
Yeah, I think I would just reiterate the benefits of being proactive in these areas. Just the best time to enter into agreement, the best time to put things in place is when everyone's ready to go, working together. The number of times you're like, oh yeah, that contract looks great, let's sign it now, versus a time where something wasn't put in place that was particularly strong and ends up coming back to bite you. So most of the time on the front end, people are willing to make changes. People are willing to engage in doing the right thing. So the front end is the time to do these. And building those tools, looking at each business relationship you have, whether that's a customer, a business partner, a landlord, software, that's a big one that comes up, a lot where people, don't really read the terms of use and end up in a situation that is not ideal. Employees, other independent contractors, thinking about each of those relationships from what could go wrong in this relationship? What are the opportunities? What are the risks? And ensuring that you kind of go through that legal infrastructure with the contracts, the insurance, the entity. And if something goes wrong, how big of a deal is it? And which tools need to be put in place in order to mitigate that risk?
Very good. Those are great. Do you have resources or things that, information online that would be of help to our listener if they wanted to learn more about you, if they're in Washington or any of those states that you mentioned, maybe do business with you, but maybe resources you have that could help them wherever they are?
Yeah, so we have a business health assessment on our website, equinox.law. And the business health assessment is about a 7-minute survey. It goes through some questions around what we call the spirit, the mind, and the body of the business. So the why, the purpose, the decision-making and corporate governance, and then all of the moving parts that keep the business rolling. And you get a 30-page report that just responds to the way you answered the questions. And we found it to be a really great tool for clients to talk with all of their advisors about. You can take this to your CPA, to your banker, to your insurance broker, and it just percolates up some ideas and thinking about your business. So that's one. And then the second is on our YouTube channel, we have a video series that goes through legal infrastructure, these concepts of entity, insurance and contract, and how they kind of flow through different parts of the business. So that could be also a useful thing to watch. They're each like 2 to 3 minutes. It's actually a nice short series.
Beautiful. That sounds fantastic. We'll have those links as well in the show notes. And, this has been absolutely a pleasure, and I've learned a lot. I know our listener likely has. Want to thank you for being on the show and sharing your expertise.
Yeah, thanks. It's been fun.
Beautiful. And with that, we wrap another episode of the Successful Bookkeeper podcast. To learn more about today's wonderful guest and to get access to all sorts of valuable free business building resources, you can go to thesuccessfulbookkeeper.com. And also, do not forget, we have the summit coming up very soon. You can go to thesuccessfulbookkeeper.com/summit and get your free access pass. And if you really want to treat yourself, you can upgrade to get all sorts of other goodies to go along with that. And I'll see you there for sure. And so with that, we do say goodbye.
You've been listening to The Successful Bookkeeper with Michael Palmer. For more information and to download the resources mentioned in this episode, please visit us at thesuccessfulbookkeeper.com. Thank you for listening.